an attorney with the law firm of Ingermeyer and Rogers. I believe you will find Stacy's presentation both educational and insightful. Stacy, may I welcome you to the presentation?
And Stacy, before you begin, this is Carla. I want to let everyone know we are recording this, so we appreciate, Stacy, you taking the time to educate on the estate planning webinar this evening. Thank you.
Sure. Thank you so much for having me. This program runs about an hour. There will be time for a few questions at the end, just so you know, if we can wait until the end, and then anyone with questions can ask. And I'm going to try and share my PowerPoint. So give me a second here. All right. Can we see the PowerPoint? I'm sorry?
It appears the PowerPoint is coming up. Let's see. Oh, we just got your regular screen again.
Oh, okay. Don't know if there's a way to turn it into there's my regular screen. Well, we might just have to look at it. Let me try again. Does this take the PowerPoint away?
We're still looking at the overall screen with the individuals that are on.
You don't see the PowerPoint?
Not at this point, no.
How about now?
Hasn't come up yet.
Let's see. Sorry.
Yeah, it keeps going back to the home screen there with the individuals on it. So you start the PowerPoint, and then once the PowerPoint is up, then you can see it, then you hit share.
Okay, do you see the PowerPoint now?
Give it a moment here. Nope, not coming up yet for some reason.
I can see it.
Oh, somebody does? Oh, there it is. Okay.
Okay, now I'm going to try and turn it into the slideshow and let me know if you lose it now. So this is the slideshow version. Do you still see it?
We see it, Stacy, yes.
Perfect. Okay.
Thank you.
All right. So, as far as this presentation goes, for those of you who can see my screen, who aren't on the phone but are on their computer, hopefully you can kind of follow along with the PowerPoint. As far as taking notes, don't worry about that. We'll have time for questions at the end. As I mentioned, it takes about an hour, and I do my best to talk in plain English. I'm not trying to use a lot of legalese that you won't understand. So hopefully you do understand everything as we try and talk in plain English. So to start with, what is an estate? That's kind of our main question here. A lot of people think that they don't have an estate, or they don't have enough to warrant estate planning. And that's not true. Anyone who owns anything has an estate, whether it's, a couple $1,000s in your checking account, or tons of life insurance and IRAs and investment accounts. Whatever you own, that's your estate. So estate planning generally talks about who handles things for you if you become incapacitated, and also where do things go after you pass away. So I'm willing to bet everybody on this call has an estate. Now the size might be different, and then there are different estate planning techniques that we use depending on the size of the estate. And as I mentioned, estate planning is really the process of figuring out who's going to handle your accounts when you become incapacitated, as well as who receives your accounts after you pass away. Now, most people just think of estate planning as their will or their trust, you know, where do things go after they pass away? But it's really just as important to figure out who can manage things for you if you become incapacitated. So whether it's physical or mental, you can't physically write out checks, you can't get to the bank, you can't remember how to balance a checkbook, or you're forgetting to pay bills. If those are the kind of issues you're running into, we have estate planning documents that help with those issues. As far as who needs an estate plan, as I mentioned, your estate is any asset you own. So really anyone who owns assets needs an estate plan. And even people who don't really own much, or maybe have more debt than they have assets, you know, think of a newly graduated college student. They might not really have much to their name, but they still need an estate plan, a very basic one, to handle those questions of who's going to make decisions for them if they become incapacitated. Now, again, there are different types of estate plans, different types of estate planning documents. So somebody who's newly graduated from college with more debt than assets is not going to need the same kind of estate plan as somebody who's retired and is very well off. But everybody needs something. Next, we have estate planning goals. Sometimes people know what they want to do when they come in as far as where they want to leave things, but they don't know that there are other options or other decisions that they need to make. So I'm just going to quickly run through these, whether or not you can see them on your screen. There are 5 estate planning goals. The first one says, I want to control my property while I'm alive and well. So we don't want to give away control before we're ready to. Number 2, I want to take care of myself and my loved ones if I become incapacitated, retaining the most control I can. So again, we want to use the least restrictive estate planning techniques to be able to manage your affairs for you. Number 3 says, I want to give what I have to whom I want, the way I want, and when I want. So most people know who they want their estate to go to, who their beneficiaries are going to be, but they maybe haven't thought about, or maybe don't even realize that they have some decisions and control over how they give that to their beneficiaries and when they give it to their beneficiaries. Number 4 says, I want to maintain my privacy and avoid court control of my affairs. So that really comes down to probate. And we're going to talk about probate and why most people want to avoid probate. And the last one is, I want to save every tax dollar, professional fee, and court cost possible. Now, for some people, this is kind of their big concern. They want to make sure they're getting the best deal. And we're going to talk about what estate plans could cost, at least in our office, before the end of the program. When should you do your estate planning? The answer is always now. If you are over the age of 18, even if you don't have much to your name, you need an estate plan because you need somebody to be able to manage your decisions if you become incapacitated. And unfortunately, sometimes people don't think about estate planning until it's too late. If you're already incapacitated, or, you know, even worse, if you've passed away, there is no second chance to do the estate planning documents. If you're not there to create your estate plan, sign the legal documents, put them into place, there's really nobody else who can do that for you. All right. So now we're looking at a slide that says common estate plans. And there are 6 things listed on this slide. We see a will, doing nothing, joint ownership, giving assets away, beneficiary designations, and revocable living trusts. We're really going to spend the rest of the program talking about these 6 different estate planning techniques and kind of the pros and cons of each of them. So the first one is having a will. We start with this one because this is usually the one that most people are familiar with. You know, just about everyone has heard of a will. Most people realize they need a will before they pass away, and that's how they transfer assets after they pass away. What's important to know about a will is that it requires you to go through probate. A will is nothing more than a set of instructions that you hand to a probate judge. The judge looks it over and says, okay, yeah, we'll follow your wishes. Unless someone comes in and argues that we shouldn't follow the wishes. But that's what a will is. It's something that we hand to the judge and they say, okay, we'll transfer your assets where you've said you want them to go. Now, what a will controls is only certain assets. So if you own something just in your name, you've got a checking account and your name is on it and your name alone, that's going to go through probate under your will. But if you own something and it has a beneficiary on it, so let's say you've got a life insurance policy and you've named a beneficiary on it, that does not go under your will. It does not go through probate. Instead, the beneficiary form will control where it goes. Another way you can own things is jointly. This is very common between husband and wife. You have a joint bank account. Both names are on there. What'll happen with that account if one of the spouses dies is that it'll go to the survivor. So that as well does not go through probate. It goes to the survivor. And then the last way to own assets is in the name of a trust. If the asset is owned in the name of the trust, that will not go through probate. It will not go under your will. It'll go under the terms of the trust. So in some situations, there's actually very little that goes through probate or goes under your will because the beneficiary form or the joint ownership controls instead. Probate is a legal process. It's a court proceeding. And what it is it's the way that accounts are retitled and given to your beneficiary. So if we take that checking account that's just in mom's name and we want to transfer it to her 2 kids, we use the probate process to get the ownership of that account changed over to the names of her kids. That's really the point of it. There are downsides to probate. So a lot of people have heard that they want to avoid probate. You know, they've heard their neighbor or a friend say, oh yeah, you definitely want to avoid probate. It's terrible. But they maybe don't understand exactly why that is. 3 main reasons why most people want to avoid probate. The first one is the cost. It's expensive to go through probate. On average, in Wisconsin, it could cost up to 4 to 5% of the entire estate value to go through probate. Where those expenses come from are there are court costs. You've got to file things with the court, and the court charges you every time you file something. You've got to publish things in the newspaper. That's part of the process that you can't get around, so you've got to pay for that. There are administrative costs, you know, paying for taxes, wrapping up, things like that. And then, of course, if you hire an attorney to go through that process, as most people do, because it's a court proceeding, and so you want an attorney to help you, the attorney's going to charge for that as well. So again, average is 4 to 5%. To compare that to some other estate planning techniques, if you have a trust, you're looking at probably 1 to 2% of the estate instead of 4 to 5%. So it can be quite a bit less expensive to have a trust instead of a will when you pass away. Next reason to avoid it is the time that it takes. Again, it's a court proceeding. If anyone's ever gone through any kind of court proceeding, you know that the courts do not move quickly. You're always waiting on the judge, you're on the judge's timeline, and things just don't move very fast. There are also certain timelines required by law. So for example, in every probate, you actually have to publish something in the newspaper for creditors. That has to be published for 3 weeks in a row. And then after that, the creditors have 4 months to make any claims against the estate. So before you can do anything at all in a probate, you've already wasted 5 months on this part of the proceeding. And that's true in every single probate. There's no way around that. In Wisconsin, our probates average about 18 to 24 months. Again, with a trust, you're looking at probably about half that time to get them done. Usually in our office, we can get them done in less than a year. So it's a little bit quicker. And then the last downside to probate is that it's a public court proceeding. So most people aren't too worried about their nosy neighbors coming to look at their will, although it is possible to do that. You know, if you don't want somebody to know where you've left things, a will is not the way to go, because they have the right to go and look at what you left to whom. So that's part of the public court proceeding downside. But the other part of it is, why would you put your loved ones through a court proceeding when there are ways to avoid it? I don't know anyone who's itching to get downtown and go to the courthouse and go and appear in front of a judge. That's usually not something that many people would find fun. And since there are so many ways to avoid probate, for a lot of people, it doesn't make sense to use the will and require their family to go through that probate process to get the estate settled. Now, wills, unfortunately, do not help with incapacity. Remember, when we're talking about estate planning, we're talking about at death, but we're also talking about at incapacity, physical or mental incapacity. So a will does not help at all with incapacity. The documents that you use, that you want to use for incapacity, are power of attorneys. There's actually two separate ones in Wisconsin. There's a financial power of attorney, also known as a durable power of attorney. And then there is a healthcare or a medical power of attorney, which is making medical decisions if you're incapacitated. So those are really the two documents that we recommend for incapacity planning. If you have a living trust, a revocable living trust, that can help as well, because the trust has control over some of the financial accounts, but that really goes hand in hand with the financial power of attorney. If you don't have the power of attorneys, what ends up happening is a court guardianship. So just like a probate with a will, a guardianship is done through the courts. It's actually done through the probate courts. And what ends up happening is a judge decides who's going to manage your affairs for you. So if you become incapacitated and you need somebody to pay your bills every month, you know, pay the credit card bill, pay the mortgage bill, whatever it is, somebody needs to petition the court, and then the court decides who's going to be able to do those things for you. So you don't get any say in it. So the power of attorneys are a much easier, quicker way to make that incapacity plan where you actually get to decide who's going to be handling things for you. All right, so now I'm going to move on to estate planning technique number 2, which is to do nothing. Now, believe it or not, if you don't have an estate plan, you've never made out a will, you never named a beneficiary on any account, the state has actually created an estate plan for you. And I'm going to take a second to mention here that I am a Wisconsin estate planning attorney. Everything that I'm talking about is under Wisconsin law. Most states are very similar, but there might be some differences. So if we have anyone joining from out of state, please just remember that what I'm talking about is based on Wisconsin law. So in Wisconsin, and in every state, but in Wisconsin, there's actually laws on the books that say where your things go if you've never created a will. And it really makes a lot of sense for most people. If you're married, everything goes to your spouse. If your spouse is deceased but you have children, everything goes to your children. Not married, no children, it'll go to your parents. If your parents are already gone, it goes to brothers and sisters, nieces and nephews. It makes sense. It follows the family tree. So it makes a lot of sense. The negative to that is it's even more costly to die without a will than it is with a will, because again, we've got judges making decisions, appointing people to handle things for you. They actually might make your relative post a bond if you die without a will and you want them to take care of wrapping up your affairs for you, to make sure they don't run off with the money. So that's an added expense. And it still doesn't do anything for incapacity planning. So remember, if you don't have those power of attorneys and you become incapacitated, you would go through that guardianship. Now, there is one upside to doing nothing, and that is that it is the cheapest option today. So every estate planning document has a price attached to it. And so if you're not doing any documents, you're not paying anything for those documents. So up front, the cost is going to be the least amount. But what I want you to keep in mind is that when you plan for your estate, you're really paying for things twice. You're paying when you create the documents, and then you're paying when you pass away or become incapacitated. So doing nothing is definitely the lowest upfront cost, but it can definitely end up being one of the highest, if not the highest, cost when you actually need to settle your estate, when you go through that probate process without a will. Our third planning technique is joint ownership. As I mentioned, joint ownership is when you own an account with another person. This is really popular with married couples. Most married couples do this, and they don't even think of it as an estate plan. It's just how married couples own things. So you've got a joint checking account between the husband and wife. When you bought your house, it got put in both the husband and wife's name, so they own it jointly. The really nice thing about this type of estate plan is that it's very simple when the first person passes away. Usually it's as simple as going to the bank or going to the county record department and showing the death certificate and saying, you know, my husband passed away, please take his name off of our bank account, please take his name off of our house because he's no longer with us. And it really is that simple. It works that well when the first spouse passes away. And again, with joint ownership, things are not going through probate. So if your goal is to avoid probate, joint ownership can work really well for that. And where it doesn't work as well is when the second spouse dies. So let's say we've got a married couple, Tom and Ann, and Tom passes away. What Ann's going to do is she's going to go to the bank. She's going to take his name off the checking. She's going to go to the county. She's going to take his name off the house, whatever other assets they have. And there's no probate there. So now everything's just in Ann's name because she took Tom's name off of it. Now, when Ann passes away, she owns things in just her own name. What's going to happen is it's going to go through probate, either under her will, or if she didn't have a will, it'll still go through probate. And that's how things will get to their kids. So joint ownership can work really well at the first death when we're talking about spouses, but it doesn't work as well at the second death. There's also a problem if our spouse remarries. So let's say Ann remarries her second husband named Dan, and now Ann makes the mistake of dying first. So when Ann remarried Dan, they did what married couples do. They opened a new joint checking account. They bought a new house and they put it in both of their names. So when Ann passes away, everything automatically goes to Dan. He goes down to the bank with that death certificate. He goes down to the county with that death certificate, and he gets everything in his own name. Now, when Dan passes away, everything's going to go under his estate plan. So maybe he had a will, maybe he didn't, but it's going to go where he says he wants things to go. What that means is that we could leave out Tom and Ann's children because they're not Dan's heirs. You know, he was a stepdad and he was a great stepdad, but he never adopted them. And so they're not legally his children, meaning that they could be disinherited by that second marriage, which clearly wouldn't be what the parents would want. So it can get kind of messy when we have second marriages. So again, this likely only postpones probate. It works well at the first person's death, but doesn't always work well at the second person's death. If there's remarriage, we could unintentionally disinherit someone. It may or may not help with incapacity planning. You know, with a joint checking account, they're not making both people sign checks. So a joint checking account isn't going to prohibit you from doing incapacity planning because that's going to be fine enough. But something like the house, if, you know, one spouse is incapacitated and the healthy spouse now needs to sell the house to free up some money or just move somewhere smaller, they're not going to be able to do that. You need both joint owners to sign off on selling the house. So if you're just relying on joint ownership as your estate plan, you would still end up in that court guardianship if you didn't also do a power of attorney. So joint ownership is not good for incapacity planning. I also like to mention the potential problems of joint ownership between generations. So what we see a lot is, husband and wife had a joint checking account, and then the husband dies, and to make things easier on mom, she adds her son on as a joint owner on that checking account. That may or may not be a good idea. Depends on the family dynamic. How many kids are there? If the son is an only child, probably no issues at all. But if the son is one of 4 children, now we might have some issues with some of his siblings thinking that he's not spending the money correctly, maybe that he's dipping into the money for his own uses. And then when mom passes away, with joint ownership, that money automatically just transfers to the surviving owner. So instead of that account being split 4 ways between the 4 kids, it all just goes to the son who was named. And, mom expected the son to divide it equally, and hopefully he will. But again, we might run into problems where, one of the siblings think that he wasn't being fair in the way he divided it. Maybe he thinks it's not fair to divide it 4 ways because he really did a lot of work helping out mom at the end of his life. So he wants to take more than 25% because he thinks that's what's fair. So you can really run into some issues by just naming a child, an adult child, on those accounts. The better thing to do would be to name the son as an agent under the power of attorney. It allows the son to still help mom in the exact same way. He can help by, managing the checkbook, balancing the checkbook, paying bills, but he's not an owner. Mom owns the account in her own name. So it just makes it very clear that she's the owner and she gets to say where things go when she passes away. Next, we're going to talk about giving assets away. So your estate plan only controls what you own at your death. So if you've given everything away before you pass away, well, then you don't have to worry about what your estate says because you don't own anything anymore. The most often where we see this is when people are trying to protect assets from the nursing home. They don't want to see everything go to the nursing home, so they want to give things away to their kids or their grandkids while they're still alive. So we're going to talk about specifically long-term care. So that might be nursing home, assisted living, having a nurse come into the home. I just say nursing home to make it easy to understand, but it could be any of those situations. So first is, how would you pay for that service? So most people actually end up having Medicaid pay for long-term care. Unfortunately, that program is not automatic. Medicaid is different than Medicare. So if you're retired, you get Social Security, you're getting Medicare. That's the program you're automatically enrolled in. Medicaid is actually considered a welfare program. It's only for low income and low asset individuals. And they really don't let you keep very much in order to qualify for that Medicaid program. As a single or widowed individual, you're allowed to keep $2,000, your car, your house and household goods, very small insurance policies, and a prepaid funeral. Married couples do a little bit better. They let you keep somewhere between $50,000 and about $137,000, depending on how much you had to start with. They have a calculation to figure that out. You still get to keep 1 car, all your household goods, those small insurance policies, a prepaid funeral. And if only one spouse, so the wife is going into the nursing home, the husband at home gets to keep their retirement accounts. But for a lot of people, that means that they won't qualify for Medicaid with the assets they have. They would have to spend down until they got into that range where they're qualified for Medicaid.
So one option, instead of relying on Medicaid and spending down the money till you get to that point, is to look into long-term care insurance. We always recommend this for everyone we talk to as a first resort. Private insurance is always going to give you more choices and more flexibility than government insurance. Medicaid is the government insurance. Private long-term care insurance is something that your financial advisor at ClearStep can talk to you about and see if you qualify. There are a lot of different options out there. And I will say, if you've looked into it in the past and you didn't like it, it was too expensive, or too many premiums for something you might not use, I would suggest asking your financial advisor about it again, because the plans have changed. There are more options and there are better plans now than there were a few years ago. So definitely recommend looking into that. If that's not something you can do, you are, maybe a little too old, you have a pre-existing condition and you don't qualify, something that we help with in our office is using irrevocable trusts to give things away. And when we talk about using irrevocable trusts, we do that because it's safer than just giving things away outright. So let's say you've got $100,000 sitting in a brokerage account at ClearStep Financial, and you want to give that away to your kids because you don't want to see it go to the nursing home. So you've got $100,000, you give $50,000 to your son and $50,000 to your daughter. Well, your son takes that $50,000 and he invested in the stock market, and unfortunately he didn't do very well, and he loses it all. And your daughter takes that $50,000 and she's always wanted to get a really nice Cadillac, and so she takes that money and buys herself a brand new car. Well, now let's say a year later you've got to go into the nursing home, and you're not going to qualify for Medicaid because you've given that money away to your kids. When you go to ask your son and daughter for that money back, they can't give it to you. Your son lost it in the stock market, your daughter spent it on a car, which is now worth maybe half of what it was a couple years ago. So there's no way to get that money back. That's why the irrevocable trust is highly recommended. It's a much safer alternative than just giving things away, because instead of giving it directly to the kids, you set it aside. It gets set aside in a separate account, and really no one is using it until after mom or dad pass away. I like to describe it as that money is just sitting in limbo. So it's out of mom and dad's name, but it's not yet in the kid's name. It will be the kid's inheritance, but they don't get it until after mom and dad pass away. So it's kind of a good way to set the money aside to protect it, but it also makes sure that the money is still there in case we need it back. One thing I will say is that using this irrevocable trust, or just giving things away, if that's the way you decide to go, is subject to what Medicaid calls a 5-year look back. So what that means is when you apply for Medicaid, they look to see if you've given anything away in the last 5 years. So whether that's to the child directly or to the trust, they look back 5 years. So if you're interested in this kind of planning, whether you're giving things away or setting up the trust, you really want to make sure that you're timing it correctly. For most people, that means setting up this kind of trust, giving things away sometime in their mid-70s, when they're still pretty healthy. The nursing home isn't on the horizon yet, but it's a thought in the back of your mind, and you want to make sure you're prepared for it if and when that day comes. So what do we put into the irrevocable trust? The best thing to put into the irrevocable trust is your house or any real estate that you have. The reason for that is that even though you put it in this irrevocable trust, let's say mom and dad put their house in the irrevocable trust, they still get to live there. So even though we've transferred ownership to the irrevocable trust, they still get to live there. Another thing that might be good to put in an irrevocable trust is any life insurance. And the reason for that is most people aren't using that cash value of the life insurance. It's really there for the death benefit. And as I mentioned, putting something into an irrevocable trust is kind of just setting it aside as an inheritance for the kids. So what better thing to set aside for the kids than life insurance, because we're really having it for the death benefit anyway. An investment account, a brokerage account, even money in the bank. If it's not money that you're using to live on, and we would sit down and look at all of the numbers and work with your financial advisor to see how much you feel comfortable moving into the irrevocable trust. But we could figure out what we can set aside in the irrevocable trust and figure out what we can protect that way. So with the irrevocable trust, as opposed to giving things away, you're not giving up total control. So with the trust, you still have some control. You get to control the trustee and the beneficiaries. The trustee is the person in charge of the trust. The beneficiary is who gets the money after you're gone. So that makes it safer and more control than just giving things away. If you just give that money to your son and daughter, you've made the gift, it's done. If you put that money into the trust and you say it's for your son and daughter, but now, a few years down the road, you think, oh, I'd really like to include the grandkids, or, my son's doing really well. He really doesn't need the money. I think I want to give it all to my daughter. With the trust, you can still make that decision. You can change who your beneficiaries are. You can also swap out the assets in the trust. So a lot of times people ask me, what happens if I want to sell the house and it's in the irrevocable trust? That can absolutely be done. It just needs to make sure that if you buy a new house, it's in the name of the trust. And if you don't buy a new house, you're just going to have the cash because you sold the house. That cash has to stay in the name of the trust, but it definitely can be done. So here I have a really simple example I'm just going to read through. So in my example, Mary is widowed. She wants to make sure that she's going to have an inheritance that she can leave her kids. So her assets are a house worth $300,000, a brokerage account worth $200,000, and an IRA worth $100,000. So what she could do is place her house and her investments in an irrevocable trust. She still has her IRA to live on, as well as her monthly Social Security and pension. So as long as she sets up this trust and then waits 5 years before applying for Medicaid, we've protected the $300,000 worth of the house and the $200,000 worth of investment. So we've protected $500,000 by setting up this irrevocable trust. So it can be a really good way to make sure that there is some money that goes as an inheritance and you don't have to worry about losing everything to the nursing home. Right. So now we're moving on to our fifth estate planning technique, which is beneficiary designations. I'm guessing a lot of you have these. Usually anytime you set up a life insurance policy, you should set up an IRA, an annuity. We put a beneficiary on for you. So that might be your spouse, your kids, whoever you want it to be. In Wisconsin, you can actually dispose of your entire estate by beneficiary designation. So you can put it on those things you think of normally, the life insurance, the annuities, the IRAs. You can put it on brokerage accounts. You can put it on bank accounts. You can even put a beneficiary designation on your house. So if your only goal is to avoid probate, beneficiary designations can do that for you. It's a good way to avoid probate, but there are some limitations just with all of our estate planning techniques. The first one is that beneficiaries don't help at all with incapacity. So if you have beneficiary designations, you still need your power of attorneys. Just because your son or daughter is named as the beneficiary on your IRA does not mean that they are privileged to any information about it before you pass away. The beneficiary doesn't come into play until after you pass away. The other problem is that you might see it as a problem, you might not, but beneficiary transfers are very straightforward and very easy, much like joint ownership.
If you've got a life insurance with beneficiaries on it, you generally just have to fill out some forms for the life insurance company, send them a death certificate, and they pay out the money to the kids. It's very straightforward. Where this can become a problem is where we have multiple beneficiaries and we've done everything in our estate by beneficiary designation. So let's say there was some final medical bills, some hospital bills that needed to be paid. There are taxes due after you pass away. Someone's going to pay the funeral bill after you pass away. If you've put a beneficiary on every one of your accounts, there is no pot of money to dip into to pay those final expenses. And the beneficiary transfer can be very quick. A matter of a couple weeks after you pass away, we could get all those beneficiaries taken care of. And so if now there are taxes due or there's a medical bill that comes in, who's going to pay that? If you've got 1 or 2 kids and they get along well, it's no big deal for them to each chip in half to pay for those things. But where it can become problematic is where you have a bunch of beneficiaries or maybe beneficiaries that aren't getting along as well anymore. Maybe your son and daughter disagreed about the funeral arrangements from the beginning of planning. And now the funeral bill comes in and it's more than they expected. And, the son didn't want to spend that much money to begin with. He didn't want to pick out those flowers or that casket. And so he says, I'm not paying because I didn't want that. And now you've got issues because there's no pot of money to pay those expenses from. It's really up to the individual to contribute to it, and they have no legal obligation to do that. So it can work well. Beneficiary transfers can work really well when we've got a very simple estate, everything going to a sole son or daughter, maybe 2. But otherwise, you're potentially in for some trouble because we don't have a way to pay those administrative expenses. All right, and now we're moving on to our last planning technique, the revocable living trust. And before I talk about this, I want to just say that a revocable living trust is different than an irrevocable trust. The irrevocable trust we really use for asset protection when we're worried about the nursing home. The revocable living trust, the one that I'm just about to talk about, I like to think of as the will replacement trust. It kind of goes above and beyond what a will does. It avoids probate. It makes things easier on the family. It creates that pot of money to pay administrative expenses. So it's used in place of the will, in place of a lot of different of the estate planning techniques I've mentioned, as opposed to the nursing home protection irrevocable trust. So there's a difference between revocable and irrevocable. The will replacement is the revocable. The nursing home protection is the irrevocable. You don't need to remember any of that. The attorney that you hire will know the difference. So I mentioned this a little bit when I was talking about the irrevocable trust, but the trustee is the person who manages the trust. The beneficiary is the person who benefits from the assets in the trust. With the will replacement trust, we actually set up the trust during your lifetime, but it doesn't change anything in your day-to-day life. So whoever sets up the living trust is the trustee and the beneficiary. They control the money, they get to spend the money. So there's really no difference in your day-to-day life. And then after you pass away, so if mom and dad set up the trust, after mom and dad pass away, they were the beneficiaries while they were alive. After they pass away, their kids are going to be the beneficiaries. They're the ones who are going to benefit from the assets in the trust. So the trustees can change, the beneficiaries can change depending on different life events. So talking about incapacity, as I mentioned, the trustee is the one who manages the assets in the trust. So if mom and dad are setting up the trust, they're the trustee. They're the ones who use the bank account in the name of the trust to pay the mortgage, to pay the credit card bill, to pay the electric bill, whatever it might be. If mom and dad become incapacitated, they name a successor trustee, a backup trustee,
to manage things for them if they can't manage themselves. So maybe they name their son as the backup trustee. Now he steps into that role as trustee, and he uses the trust checking account to still pay all of those same bills. So we still use the trust account to pay the mortgage, to pay the electric bill, to pay the credit card bill. So the person in charge of the account might change, but the account is still mom and dad's, and it's used to pay their bills. So that's how a trust can be used as incapacity planning. It works very much like the financial durable power of attorney, in that you name somebody to manage your affairs for you in case you can no longer manage them yourself. So the person you name to control your property is your successor trustee. You can leave very detailed instructions of how you want your trust to work, what you want that money used for. So we have people who say, you know, I don't want to go to a nursing home. I want to be taken care of in my home. We can say in your trust that that is what your trustee should do. Instead of finding, an assisted living or a nursing home, we're going to have a nurse come into the home and we're going to spend your money on that type of care. You can say that, you know, I've always left money to this charity or to my church. And so if I become incapacitated, I want to make sure that my son, as my trustee, continues to make my monthly or annual charitable donations. So you can put those very detailed instructions into a trust. So will a trust solve all of our estate planning goals? And for the most part, the answer is yes. With the trust, you maintain the most control as possible. With the trust, you get to say how and when you want things to go to your beneficiaries. You definitely maintain privacy and avoid court control because there is no probate with a trust. That's one of the big benefits. As far as whether or not it's going to save every tax dollar, professional fee, and court cost possible, that depends. So it depends on whether or not your estate planning goals require a trust or not. So for those with very simple estates, very straightforward estates, a trust might be overkill for them. And we're not going to try and sell you a trust if you don't need it. So it depends on the size of your estate and what your estate planning goals are as to whether or not a trust is going to be the right option for you. But with the trust, you do eliminate a lot of those problems that I mentioned with the other estate planning techniques. So I'm gonna talk about that in just a second. I do want to mention estate tax. Because people do ask about this. How much is the estate tax? Do I need a trust? Do I have enough money for a trust? And the answer I think safely say to everyone on this call, everyone I've ever met in my life, is you're not going to pay estate tax. The current estate tax exemption is over $24 million for a married couple. So if you've got more than $24 million, you have an estate tax issue. If you have less than $24 million, don't worry about it. So does the living trust how does the living trust avoid those problems with our other estate planning techniques? So the first one, the big one for a lot of people, is probate avoidance. So remember, if you have a will or if you do nothing, you go through probate. So with the trust, you do not go through probate because things are owned by the trust. We call that funding. When you retitle assets into the name of the trust, that means you funded the trust, and that's really important because if you remember that slide from way back at the beginning, if things are owned in your own individual name, they go through probate under the will. If things are owned in the name of the trust, they go under the trust and avoid probate. So having things titled correctly is very important. Next is incapacity planning. So some of those estate planning techniques like joint ownership and beneficiary designations didn't deal with incapacity. You needed the power of attorney to deal with that. And again, with the trust, you've already named a successor trustee in your trust that can take over management of your estate if you become incapacitated. So that's built into the trust. Asset and lawsuit protection. Now, this isn't something that we talked about, but can be a really good big benefit of the trust. When you leave your inheritance to your children in trust, you can actually leave it to them in a protected way. Some of the big things that we like to highlight are protection from divorce. So if your son has a rocky marriage and you're worried about his soon-to-be ex getting half of his inheritance, if you leave that to him in a trust, it's going to be protected. Lawsuits are another one. You know, someone could be driving down the road, they run a red light, it's their fault, they get sued. If their inheritance from you is in a trust, it's protected. It can't be a part of that lawsuit. Bankruptcy, you know, the kids fall on hard times and they've got to file for bankruptcy and they end up losing their inheritance to pay off their debt. If it's in a trust, it's protected. It won't be part of that bankruptcy proceeding. And the last one I like to mention is any kind of a disability benefit that a child or a grandchild is receiving. Some people think that they can't leave to their disabled child because they'll get kicked off of those government benefits. If you leave to the child in a trust, they are still eligible for those benefits. So it's a good way to make sure that we're treating all the kids equally, even if we're worried about those government benefits. Remarriage protection. So this is going back to our joint ownership example, where our surviving wife remarried and then accidentally disinherited her kids. If her and her first spouse had a trust, they could have had protection in their trust to make sure that everything would go to the kids, or at least half of the assets would go to the kids, rather than everything going to the new spouse. So it can be really important in a second marriage. Special needs protection, I've already mentioned that if any of the beneficiary is receiving a government benefit, inheriting a trust is a way to protect those benefits. And life estate. So a lot of people want to see their inheritance go to their son or daughter. And if their son or daughter isn't there, they want to make sure that it goes to the grandkids rather than to spouses. And with a trust, it's really easy to do that. You can say what happens to your son's share if he passes away, it goes to the kids rather than the grandkids, or if he doesn't have kids, it goes over to your kids rather than to any in-laws or somewhere else you might not want it to go. So it gives you a little more control over where that inheritance ultimately ends up. And I think that's really about it. Sorry, just the last slide here is just a little bit about our law firm. And I'm gonna stop sharing my screen now so you can see me again, hopefully. We are a law firm, just a little bit about us. We're based in Milwaukee, Wisconsin, but we also have offices in Cedarburg and Waukesha. And we focus on estate planning and elder law. We're not the kind of law firm that does family law or criminal law or anything like that. We really focus on what we know best. And the way our office works is that we do everything on fixed fees. I did mention that I would say a little bit about prices. We don't try and sell you into more than you need. If all you need is a power of attorney, that's all we'll charge you for. If you got something more complicated and need a trust, we'll set up a trust for you. But we do everything based on fixed fees on the work that needs to be done. And just an estimate of our prices. It could be as much as, $7,000, $8,000 if you're doing a full estate plan with a Medicaid irrevocable trust. That's kind of our most expensive. If you're a married couple looking for a trust, you're probably looking at $4,000 to $5,000. If you're single, maybe $1,000 less than that, $2,000 to $3,000. If you just need a will,
maybe 1,000. And if all you need is power of attorneys, I do power of attorneys for people all the time where that's all they need. We charge just a few $100s for each of those power of attorneys. So there's really quite a range depending on what you actually need. And we offer free consultations. So we will sit down with you for, an hour, hour and a half, get to know a little bit about you, your family situation, your financial situation, and see what the best estate planning techniques for you would be. So if that's something you're interested in, you can talk to your ClearStep financial advisor about how to set that up. And Dave, do you want to say something? Otherwise, I think I saw a couple questions here or just one question here in the chat. Do you want me to go ahead and read that?
Yeah, you can go ahead. Yeah, sure.
Okay. So Dan asked, I called the revocable living trust a will replacement trust. Don't we still need a will to cover other matters, or can everything now be combined? So when we do a living trust, a will replacement trust, our goal is to make that the centerpiece of the estate plan and the only document that gets used when you pass away. But when we do a will replacement estate plan for someone, we do still do the other documents that I talk about. So you would still have a financial power of attorney to cover anything that's not in the name of the trust. It actually covers things like dealing with your credit card company, dealing with the cell phone company, dealing with the cable company. So there are things that you still need that for. And we also still do a will, even though the trust is the will replacement and the centerpiece of your estate plan, we still do a will as a backup document. We call that a pour over will. And if everything is done correctly, we should never need to use it, but it's there just in case something doesn't get titled in the name of the trust. We can use that will, that pour over will, and all it says is, oops, we forgot this, put it in the name of the trust and the trust will tell you what to do. So Dan, hopefully that answers your question. If not, let me know.
Well, thank you, Stacy. I feel you provided a lot of valuable information this evening, and I'm sure we have several people in the audience who are now thinking about some of the estate planning strategies you've talked about, and are sitting there wondering, how they apply to them. So I want to tell everyone in the audience, much as you said also, that if they have concerns or want to get further information, they should reach out to the ClearStep team member that invited them to the presentation this evening. And that team member will make sure that there's arrangements for that information to get back to you.
Dave, I think there's another question here.
Some things came up.
Yeah, is an attorney necessary to complete all the documents of an estate plan, or is an attorney necessary to sign off on the documents? There are online products such as NOLO that appear to be comprehensive.
Yep. So to answer that question, is an attorney necessary to create these documents? The answer is no. Some of the documents are actually provided. As I mentioned, Wisconsin has some laws on the book that help with estate planning. So they can say where things go if you die without a will. They also have what we call statutory forms. So you can just, you can type into Google Wisconsin power of attorney, and it's a free form that comes, you get it online. It's created by the state of Wisconsin, free for anyone to print off and use. But those forms, and I'll say all forms are not created equal, whether you get them, for free online, if you pay for them through NOLO, wherever you get them from, just be careful. Practicing law, legal documents are one of those things where you really get what you pay for. The basic cheap version will probably get the job done. It might get the job done half of the time. It really depends on what you need it for. So I can tell you, for example, with that financial power of attorney that you get from the state of Wisconsin for free, it will not work if you're trying to protect money as you're going into the nursing home. So I've had people come to me where they say, Mom is going into the nursing home and we're trying to protect some of her money And I'm the power of attorney. How do I protect her money? And I say, well, that's great. You know, she has the power of attorney. She's incapacitated. She can't do it anymore. Let's take a look at the power of attorney. And the power of attorney from the state of Wisconsin, the free one that they give out, does not allow us to update any beneficiaries. It does not allow us to make gifts. It wouldn't allow us to set up an irrevocable trust to protect assets. It wouldn't allow us to, you know, potentially spend money or loan money to kids to try and get someone qualified for Medicaid sooner. So, you know, the forms can really work in a pinch. They might work in a very basic situation, but if you're hoping to do something particular, just know that not all forms are created equal. And that's why you might want to go to an attorney. And even then, you know, not all attorneys are created equal. I like to think that we're in a more unique understanding situation because we do not only estate planning, but we do elder law. So we see the needs that come up as people age and they're worried about the nursing home protection, how to protect money. That's somebody who does, you know, estate planning and family law. They're not focused on those sorts of things. So it's a little bit different with everyone.
So Stacy, also, I know generally you talked today about estate planning information, which is generally acceptable or true for all states or almost all states. I know we have some people on different states here. So if you are from another state, Stacy, do you practice law in different states, or do you recommend people see attorneys in that state? And then I would contact your financial advisor for referrals.
Yeah, so every attorney is licensed state to state. I am only licensed in Wisconsin. There are plenty of attorneys out there, especially attorneys that are practicing on the border of one state or another, that are licensed in maybe 2 states, sometimes 3. But if you're from outside Wisconsin, you really do need to talk to an attorney from the state in which you live. Again, I'll just say everything I talked about generally is, you know, good estate planning advice no matter where in the country you are. But some of the more fine details about, you know, what does the power of attorney allow? How long does a will take to process? What are the prices? Those are things that are more specific just to Wisconsin.
Okay, thanks, Stacey. So contact your financial advisor for referrals if you are from a different state. Also, there's another question, Hoff. How often do you need to update a will or a trust?
Yep, great question. How often do you need to update your documents? General rule of thumb that we tell people is every 3 to 5 years, they should get them at least reviewed. And in our office, we do reviews at no charge, so we do try and encourage that. We know people get busy and they don't always come back every 3 to 5 years. The better answer is it depends on each person, but it's anytime you have a major life event. So if you get married, if you have kids, those are major life events where you should be updating your documents. If somebody becomes terminally ill, if somebody passes away, those are times you should be updating your documents. For younger families, you know, they probably created a will when their kids were just infants or toddlers, and now the kids are all through college and they've never thought of coming back to update their documents. That's probably a good time to update the documents. You know, when you retire, that's always a good time to revisit those documents as well to make sure that you've got the right people listed in the trustee or power of attorney roles. Make sure you've got all of your beneficiaries set up correctly. So again, general rule of thumb is every 3 to 5 years. People usually wait a little bit longer than that, but it does need to be done from time to time, especially whenever there's a major life event.
Okay, I think that's it for questions in the chat box. So, any last questions quickly here? All right. Well, thank you very much for being here tonight, Stacy. We do appreciate you taking the time to spend with us and share your knowledge. Thank you.
Thank you again for having me. And if anybody has questions that were I guess, more particular to their situation, or they didn't feel like asking in front of the group, as Carla mentioned, reach out to your financial advisor, and they can either give you my information and you can ask me directly, or they can ask on your behalf. And I'm happy to answer questions. I never charge for answering questions, so feel free to use me as a resource.
Well,
We
thank you very much,
appreciate you,
Stacy.
Stacy. Thank you.
All right, thanks. Have a good night, everyone.
Good night, everyone.
Thank you. You too.